you know, since we can lay this at the feet of my favorite president who said that sex did not include oral sex. There's Clinton, and the kids are now using Clinton's argument that oral sex is not sex, and so kids are engaging in oral sex much more frequently, you know, between same-sex and opposite-sex kids, and they're engaging in a fair amount of it, and it clearly the laws are about prohibiting sexual behavior that is not for the purposes of procreation. And the reason is, as one of my friends who's an advocate in this particular area about youth rights says, you know, Dan, it is extremely difficult to go to any legislature, including the California state legislature or the New York state legislature, and argue on behalf of anal sex between minors. It is. It's very difficult. He says, it's like trying to argue, you know, you're arguing, it's not apple pie. And so you're trying to overcome a tremendous amount of heterosexism, a tremendous amount of homophobia, as well as some really strong strains of puritanical thinking about adolescence and sex. This is one of the places I mentioned earlier about, I think, our profound societal ambivalence about teenager sexuality and children being sexual as well. That on the one hand, I couldn't agree more strongly about the need to protect kids from exploitation and assault. There's just no. On the other hand, most children developmentally engage in sexual behavior that's neither exploitative nor assaultive. It's not technically legally consented to because they can't consent, but it's voluntary. And the question about whether the state should get involved in children's sexual behavior at this level is a very profound one. On the one hand, if you make this kind of report, are you violating the APA ethics code or the NASW ethics code or CAMFT ethics code? And I think there's an argument that we are. And on the other hand, we're violating the code by failing to abide by the law. It seems to me that there are three things that we can do. One of them relates to a question that both of you were asking about what's the point? Like, why would we report this kind of sexual behavior among other kinds with kids? Why would we call about oral copulation when it's voluntarily on the part of two kids? Well, first, the law says we have to. But secondly, I think this ties very intimately in with doing informed consent with kids. That we let kids know very specifically what we have to report. And I worked with teens for many years, and one of the things that I did was to say, okay, so I have to make child abuse reports. And they go, uh-huh. And I said, and that includes sexual abuse reports. And depending on the kid, they'll get a little uncomfortable, and they'll giggle or make a crack or something. And I say, so, but I want to tell you what I do have to report and what I don't have to report. I don't have to report if you have intercourse. I don't have to report if you have intercourse with somebody who's close in age to you, because you're 15, okay, or 14. But the law requires that I report oral sex and anal sex and any kind of penetration of an anal or genital opening. And some kids will go, ew, you know. Other kids will go, oh. And then they choose. The kid chooses whether to tell me. You were talking about the differences in therapists' approach to this. My sense is that I want kids to be able to feel free to ask for help. And often they'll do that by disclosing that information once I've told them that I have to report it. On the other hand, so that's why I think there's some meaning to it, and it makes some sense that, okay, I have to report this. The kid has some sense that something will happen. On the other hand, like you, I've had many kids who are, I've had kids who are cagey, you know. They'll say, well, I'm not doing anything like that. And it's hard to know whether it's bravado or whether it's, you know, wish fulfillment or whether it's actual. And I'm not required to make a report about that. Sometimes I do think kids slip. And then I'm required to make a report, and it's damaging. But the way I balance the ethical concerns around what the law is requiring is that I give very explicit informed consent so that kids know, the extent that it can be given, the kids know what they're getting into. And particularly when I'm working with sexual minority populations, I think it's really essential that kids know what will have to be reported and to have a conversation about it that's very explicit. Not just telling them, but also engaging the kids in a discussion of, this is what it means. Is it homophobic? It absolutely is homophobic. It's also puritanical. It's also saying sex for kids is not okay. Having a conversation about that and also saying I'm bound by my legal duties to make a report, but you have a choice about what you tell me. It does, in my opinion, limit what kids tell us. There's no question. And I think it truncates some of our ability to do good therapeutic work. but I don't know any other way to get her to negotiate both the legal and ethical mandate, and also the fact that I think, particularly as kids get older, they have a right to know what they're getting into. Even if formally they don't get informed consent, they need to know this kind of stuff. But unlawful sexual intercourse, anytime a minor engages in sexual intercourse, it's illegal, which means that about 60 or 70% of minors, by the time they get to the end of high school, maybe 55 or 60%, depending on who you read, have engaged in illegal behavior. I'm shocked. Shocked, I tell you. Okay? And so for many years, those laws have remained on the books without being enforced, except if there are allegations of assault or abuse that are difficult to prove, except you know the two folks, the minor and the person who engaged in intercourse with them, that they did, and they admit to it. Then you may have an ability to prosecute. So what happened was, about 7 years ago, there was a law put in place that requires the reporting of unlawful sexual intercourse in just a very narrow set of circumstances. Historically, I'm sure actually that it's been against the law for many, many years, but I don't know about the patterns of enforcement. And I think it was more kind of enforcement, convenient enforcement, and use when it was socially necessary, or when it came before the DA's office, that sort of thing. Still, this 14 and 15-year-old engaged in sexual intercourse with somebody who is 21 years of age or older as a mandatory report means that a 16 and 17-year-old having sexual intercourse with somebody over the age of 18, while still illegal, is not a mandatory report. It also means that two 15-year-olds having sexual intercourse, as opposed to two 15-year-olds engaging in oral copulation, two 15-year-olds having sexual intercourse is not a mandated report. So a 14-year-old brought this home to me in a very kind of poignant way one time. His parents brought him in for a number of problems, and I did my usual very kind of detailed informed consent around reporting of abuse, and particularly sexual abuse. And this fairly smart kid said to me, "So, Dr. Dan," which is what he wanted to call me, "you're telling me that the state of California says it's okay to have sexual intercourse if you're like two 14-year-olds. I said, "Yes. But not if you are having sexual intercourse with somebody who's like 21 or 25 or older." I said, "That's right. And they also say that you have to report me when I, like, he called oral copulation some name that I've never heard, but anyway, when I engage in oral copulation." That's right. So you're telling me that the state of California believes oral copulation causes babies. Is that correct?" So, in the context of why they were limiting, the legislature was limiting the age ranges with respect to sexual intercourse, you can see that some of the illogical nature and prejudicial nature of the rules become apparent even to 14-year-olds. But the other thing to be aware of with respect to this idea of 14 and 15-year-old and somebody 21 years of age or older is, even if you've got just two 14-year-olds or a 14 and 15-year-old, if you have reason to believe or you suspect that one of those kids is abusing or exploiting the other, all bets are off. The age differences don't matter. You just make a child abuse report. Why? Well, if they're forcing them into sexual conduct, that's abusive, you make a report. You don't have to be concerned about the age difference. Same goes for what's called lewd and lascivious conduct on a minor. Lewd and lascivious conduct, I mean, you may wonder, and actually sometimes I think about this, it sure narrows the range of fun behavior kids can engage in legally, to say that you got to report oral copulation, you got to report sodomy, well, okay, you got to report digital penetration, and with certain age differentials, sexual intercourse, but then lewd and lascivious conduct you don't have to report. Well, what the heck is that now? Well, it's petting, use an old-fashioned term. It is stroking one another, it's viewing one another, it is engaging in more light sexual behavior, kissing passionately perhaps. And that's not a report, but it can be. And it can be if you have a 14 or 15-year-old engaged in lewd and lascivious conduct with somebody at least 10 years older than they are by birthday. Okay? So one child under 14 also, and one 14 or over, got to report, right? Lewd and lascivious conduct, messing around. But you also have to report when there's that 10-year age difference with a 14 or 15-year-old. By birthdays, they had to pass an amendment to say by birthdays, by the way. What it means is that you don't count the 10 years in terms of I'm 14 and the person is 24. You count it by I'm 14 and I was born on such and such a date, and it has to be 10 years from that date. 10 years by birthday. Yes, it was a way of clarifying here's the cutoff point. Okay, so they passed a law to clarify that. Now, when both kids are under 13, both of them are 13, you don't have to report. I want to actually ask you to exercise some caution about that assumption. There are some older court cases that support your view, and I actually think they are logically reasonable. These are court cases that said, look, if you have two kids close in age, there's no abuse going on, and they're engaged in lewd and lascivious conduct. And interestingly enough, lewd and lascivious conduct is kind of a catch-all phrase, which can include other kinds of sexual behavior. So this is where the muddy waters occur around oral copulation, digital penetration, or even intercourse for that matter. In this case, it had to do with intercourse, because it was the Stockton Pregnancy Center that was appealing a decision by a lower court in one, actually a couple of cases. The problem is the laws changed in 1998 and 1999, the laws upon which this particular provision and the cases rested. The sections changed so that we had to report that with that 10-year difference, and it threw into some uncertainty whether we could rely on the older cases that allowed us to avoid reporting with two kids who met what's been called the playing doctor exception, engaging in lewd and lascivious conduct when the kids are close in age, the behavior is voluntary, they're not close blood relations, like, so it wouldn't be defined as incest, and there's no other evidence of abuse. Well, there are two publications that imply that the state believes these old cases still apply and that we still have a playing doctor exception. If you read through the California Child Abuse and Neglect Reporting Law, you will see that they talk about the fact that if you have two kids close in age and so on, you don't have to report it. This interpretation by the Department of Social Services suggests that they believe those exceptions still apply. And there's a publication by the Attorney General's office that is focused on state social services agencies that also suggests that they believe that these rules still apply. And that's somewhat comforting. However, no courts have ruled on it since the law changed. So be cautious. If you've got two kids under the age of 14 and you've got any question or concern, it's time to consult. It's time to call CPS, talk to the emergency services supervisor, and if they say to you, report it, then you do so. Okay? But be careful on these. You may, in fact, get this information on the licensing exams. They may ask you questions about it, although from my understanding, for years they haven't asked about this. I think it's reasonably safe to say, that the playing doctor exception applies, but I'm a little bit more conservative. I'm kind of worried because no court has ruled since the statute changed, and that concerns me. I don't know if courts are going to follow the earlier precedent or change their course as a result of the statute being changed. When in doubt, call, get consultation, and make a report, and also use informed consent.